as we have discussed right now, settlement agreement simply means that any agreement of a compromise that is reached between two parties who are in a dispute already. Okay. A settlement of a compromise can only be entered into by two parties who already have an ongoing dispute. Now, the objective of that settlement agreement is to, cease the dispute and to reach a monetary consideration or to reach an out-of-court settlement between the parties without pursuing the litigation further. And I think, as Priyanka also said, yes, and to ensure that there are no future conflicts or future litigations of this same, right? I will give you a very basic example of this. Say you are an employee, okay, and your employer has wrongfully terminated you, right? Now, settlement agreements are very common in the employment industry. Why? Because any time an employee files a wrongful termination suit against the employer would want to make sure that such a case is settled outside court and not through the litigation procedure. Can somebody tell me why the defendant, would want to settle their case in a settlement agreement and not through litigation, right? For example, consider the employer is a very, very famous person. For example, say Nike, Netflix, right? Now, these brands have something to lose in terms of goodwill and reputation in case an employee, tarnishes their image with wrongful termination, with wrongful treatment or mistreatment of employees, right? So they would definitely want to ensure that this case is not further pursued in the court so as to avoid any litigious bad reputation. Yes, as Dev Datta has rightly pointed out. Okay. For this matter, the parties would want to make sure that the entire matter is settled in a hush-hush manner by executing a settlement agreement and thereby further ceasing the ongoing litigation. Okay. Now, the basics of this is firstly this. When can a settlement agreement be entered into? It will be entered into either before, so whenever the claim is filed, okay, say I am the employee who has been wrongfully terminated. Now, I will be filing a wrongful termination suit under the courts, right? Now, as soon as that suit is filed, then from that stage onwards, till a judgment is pronounced by the court, the parties have the option of settling the matter through a settlement agreement. Okay, this can only be done by the agreement is executed in front of the court. Okay, the court gives the execution of the agreement, and the court will also adopt the settlement agreement into its judgment or order. Okay. Now, why does this happen? Because if the parties have already entered into a settlement agreement, means that the entire dispute has been resolved already, right? So now that the court, the litigation is ongoing, the judge will simply pronounce a judgment where the settlement agreement is just imbibed into, right? So the settlement agreement becomes a judgment in effect by the court, right? But this can only be done when there is a claim in place. Okay, if there is no claim in place and the parties want to enter into a settlement agreement beyond the scope, then that will not be termed as a settlement agreement executed in court. Okay, and the binding and enforcement of that also will not be adjudicated under the courts. Okay, two basic things is, firstly, the parties will always initiate the notice of getting into a settlement agreement, and it can be filed from when a claim is filed until the time a judgment is not given by the court. Now, so what is a settlement? As we've seen, it is simply saying that the parties have mutually agreed for non-instituting a lawsuit or ceasing the institution of the lawsuit, right, in return of a monetary compensation upon being aggrieved by the other party. So if the employee has filed a wrongful termination suit, the employer, for example, if somebody like Nike, Netflix, right, Facebook, right, they have a lot to lose in case their reputation takes a hit. So they will approach the employee and ask them to settle the matters in a hush-hush way, which is entering into a settlement agreement, right? They are going to offer a certain amount of money to the employee in return of dropping the lawsuit against them, right? And this is something, the terms of the settlement agreement is really, really important to be very, very mutually beneficial to both parties, okay? In the sense that firstly, the monetary compensation is provided for the aggrieved to drop the suit. So that is automatically benefiting the person against whom the suit was filed, right? And how is it benefiting the claimant? They are getting a monetary compensation, a very hefty monetary compensation to settle the dispute without involving the litigation aspect. Okay. Now, a settlement agreement therefore can be construed as a legally binding agreement between two parties, either before or after the court action begins, which means when the claim is filed but the hearing is yet to begin. Okay, even then the settlement agreement can be finalized. If the hearing has started and litigation is in process, even then the settlement agreement can be finalized until the judgment is pronounced by the court, right? So that is the time period for the parties to reach into any type of settlement. Does a settlement agreement need to be notarized, registered, stamped, etc., right? Now here also, firstly, none of these is mandatory here in India, okay? However, USA has a mandatory notarization provision, but because a settlement agreement is done in pursuant of an ongoing litigation and it is enforced and observed in front of the court, okay, in front of the judge, it need not be notarized, registered or stamped, okay, because it has been signed by both the parties and the judge gives it an approval by incorporating the terms of the settlement agreement into its judgment, right? So there is an automatically binding enforceability, right? But yes, after the case has been dismissed, the court no longer has the power, right? So we have already gone through this. Once the judgment has been pronounced, whether the case was dismissed or one of the parties was awarded remedies, etc., once the judgment or the order has been given by the court, no longer can the settlement agreement be executed. Then we come to the jurisdiction. Now see, in the USA, okay, in the USA, as we know, federal courts are going to hear matters pertaining to national interest and also pertaining to the fundamental rights of the citizens, okay? Now, this does not mean that the state courts are excluded. Of course, the states also have jurisdiction to try this matter if the claimant is approaching the state court directly, okay? But if the citizen is approaching the federal court also directly, that will be acceptable, because here a settlement court, only if the objective or the purpose of the settlement agreement is to restore the rights, the fundamental rights of the claimants that has been taken away, right? For example, if there is wrongful termination, this is a fundamental right to trade, okay? The citizen has a fundamental right to work, and because of no fault of theirs, because of the employer's wrongful termination, they have been deprived of this fundamental right, okay? For this, they can directly approach the federal court as well as the state court. Now, just because the federal courts possess the jurisdiction, again, I will repeat, it will not automatically exclude the jurisdictions of the state courts. The citizen has the right to approach any of these courts and the matters will be heard pertaining to the same. Right?